Mr. Murali Pillai.
Mr. Deputy Speaker, sir, I would like to declare my interest as a lawyer in private practice. These two bills are presented after public consultation, and the move on the part of the Ministry of Law to consult before introducing these two bills is to be commended. The stated aims of these bills are to streamline the statutory regimes for the recognition and enforcement of foreign judgments into one under the REFJA, and to take the necessary steps to ensure the recognition of Singapore's civil judgments overseas on the basis of the reciprocity principle between countries. I welcome and support these aims. As mentioned by the Honourable Senior Minister of State, Singapore is already a well-recognized dispute resolution hub with the SIAC, SICC and SIMC. In the context of the litigation in courts, the setup of SICC was a game changer. The SICC, a division of the High Court, consists of top international jurists in addition to Singapore Supreme Court judges who all have deep expertise, skill and experience to try complex international commercial disputes. Singapore's ratification of the Convention on Choice of Court Agreements, a point that the Honourable MP Mr. D'Souza mentioned, allows judgments issued by the Singapore Court pursuant to exclusive choice of court agreements to be recognized by signatory countries. This was a big step in achieving the policy aim of ensuring the wide recognition of Singapore judgments. It is proposed under the REFJA Amendment Bill that the statutory base for recognition of a foreign judgment is to be enlarged. The effect of this is to allow a Singapore judgment to be similarly recognized by competent authorities in foreign jurisdictions through the reciprocity principle. Subject to the comments I will shortly make, I support the enlargement of the statutory base. Before I deal with my comments on the bills, I would like to make some suggestions of steps that can be considered to increase the attraction of Singapore court judgments and Singapore as a dispute resolution hub. I had previously suggested in this House that Singapore consider the viability of entering into the Apostille Convention, which deals with certification of a document's validity for legal purposes in signatory states. There are currently 117 countries which are parties to this convention. This would significantly cut down the cost and labor involved in legalization of documents. I understand that the Ministry of Law is looking into this matter and would appreciate an update. In the same vein, I would suggest that the government consider the viability of Singapore signing the Convention on Service Abroad of Judicial and Extrajudicial Documents in Civil and Commercial Matters Act. In other words, the Hague Service Convention, which currently has 75 countries as contracting parties. This will enable easier service of process, commencing legal action on parties situated in convention countries. Otherwise, it may take an inordinate amount of time through the usual consular authorities routes to serve process, and this may take between 3 to 5 years depending on the countries involved. Returning to the bills, I would like to ask about the scope of recognition and enforcement of an interim and non-money judgment under the proposed amendments to the REFJA. I note from the Honourable Senior Minister of State's speech that injunctions are considered, also orders for specific performance. May I ask, how about search orders, how about declarations? Specifically in the context of interim injunctions, I'm heartened to note that the bill does allow for recognition of interim freezing orders targeting assets of a defendant in Singapore issued by a foreign court so as not to make a subsequent final judgment of the foreign court nugatory. This is to be welcomed because previously, in my view, there was a black hole where a defendant can exploit because the individual may be situated in one country and have assets in another country. The current legal position in Singapore is that local courts may not necessarily grant an injunctive relief purely in aid of foreign proceedings. In an interconnected world, this makes less sense, and certainly it's not the case in respect of arbitration proceedings. Under the International Arbitration Act, the Singapore court may issue interim relief in respect of arbitration proceedings. So with this amendment, we can potentially resolve this anomaly. And through the principle of reciprocity, I hope that the Singapore interim judgments will similarly be recognized overseas so as not to render a subsequent final judgment of the Singapore courts nugatory. I now turn to civil forfeiture action taken by sovereign governments. Now, there are certain jurisdictions which assert wide jurisdiction over assets wherever it may be situated. For example, we have the unexplained wealth orders issued by the UK courts, aimed at assets overseas. These proceedings are civil in nature, but if you look at it carefully, in reality, these orders may be viewed as penal in nature and may not be too different from a tax judgment or fine or other penalty, which is not covered under the REFJA. And this may also be seen as a sidestep from what would otherwise be a subject matter of a mutual legal assistance treaty request between countries. There could also be issues vis-à-vis bona fide third parties who may have to deal with assets that are ordered to be forfeited by a foreign court. May I ask how the proposed amendments would deal with foreign civil forfeiture orders? In this regard, it may be useful to note how other jurisdictions deal with such orders. For example, in New Jersey, there's a separate piece of legislation dealing with civil asset recovery orders made by foreign courts. It does not confer automatic recognition of such orders. It will involve the Attorney General, who will make a decision in his discretion whether or not to make an application to freeze and confiscate the assets which are subject matter of the foreign civil asset recovery order. Finally, I welcome the safeguard that is sought to be introduced in form of the proposed Section 4, subsection 3A of the REFJA, under which the court may only register a non-money judgment if it's satisfied that the enforcement of the judgment would be just and convenient. I seek an elaboration of the factors that the court is supposed to consider before deciding it is just and convenient to recognize a foreign monetary judgment, or if it's not, what are the circumstances in which the judge would then decide to convert it into a money judgment. Notwithstanding my comments, I support the bills.